Hey, good morning, everyone. Welcome to this event hosted by the Philip K. Chuan Center for Chinese Law. My name is Ying Xiang. I'm the director of the center, and I know this is the final term period, so I appreciate everyone for coming. So today, we are very delighted, honored to have Jamie Horsley with us. Jamie is a senior fellow at the Pulse Center at Yale Law School and a non-resident senior fellow at the Brookings John Thornton China Center. She was also formerly the executive director of the Yale China Law Center, and her research involves a broad range of issues concerning governance and regulatory reform in China, especially on information disclosure and data governance. So today we're very honored to have her to talk to us on China's quest to dismantle data silos, operationalizing government data sharing through law. Welcome.
Thank you very much for the introduction and the invitation to talk here. I'm really delighted to do this because for me, this is sort of a work in progress. As I was talking with some, I thought I would just do a quick analysis of the regulations and that'd be it. But the more I started looking at them, the more questions they raised. And I keep going down rabbit holes trying to figure out how this all works. So hopefully some of you can help me figure parts of that out. So I was interested in this topic for at least three reasons. Number one is, as mentioned, I've been working in sort of the information area with China for a long time. I've been at Yale now almost 25 years. And one of my first projects going there was working with the Shanghai government, the former federated, so the legal affairs offices. And they were interested, and this was like 2002. The leaders wanted to make Shanghai a financial center. They realized transparency was important, and they wanted to have a kind of Freedom of Information Act, for Shanghai. And it turned out Guangzhou already had one, but they wanted theirs to be better because Guangzhou's was not being used. And so starting working with them over the years and then with other provinces and eventually the state council, and then looking how it was operationalized there too, it's kept me really interested in the field. So now data is the new information, sort of. And so I've been trying to figure out what's happening in the data field. Another reason is because, of course, in the US, we have ongoing debates about exactly this issue now, dismantling data silos. The US system for intergovernmental sharing is not as clearly set out as these regulations do for China. And there's a widespread perception that the current administration is violating the privacy law by aggregating lots of data from different departments, where we've had very strict laws for years, decades, for census, for tax, for Social Security, that American citizens, companies are promised that their data will be kept private and confidential, only used by the department for a specific purpose and not shared, so that people would be willing to give their data to the government. And those promises are being broken now as they aggregate data. Plus, they were using an outside company named Palantir. So a company was also being brought into the problem too, getting access to all of this data. And it gets more complicated, but a lot of lawsuits are going on at the moment. So it makes it even more interesting to see what's happening here in China. And then the third reason is why, as you know, in the US-China relationship, everything has become securitized. And so data, because of its close relationship to AI, is seen in some quarters as sensitive. So there are recent articles that talk about data, that China is seeking data dominance, and China wanting to weaponize their data and that kind of thing too. So we're trying to figure out what are the motivations behind this and how to explain that to, US audiences, that they have a lot of other legitimate kind of normal governance reasons, as well as, like the US, wanting to feed into the AI project as well. So the other thing I want to say about this PowerPoint, I was telling folks too, I'm learning AI. I was invited to speak at a conference over the weekend on AI and education. So finally had to start using it. So I've been using AI a lot for the data work. So I asked it to take my draft paper and turn it into PowerPoint for me. And it's evidence of what the problems with AI are. I thought it would just take my outline and put up a PowerPoint. I looked at it quickly. I thought, oh, that looks good. Now looking at it, I realized they dropped stuff I wanted in it and they added their own stuff. And so really felt quite annoyed, again, what AI is doing. But that's why you have to be so careful using AI. But anyway, as I said, the US, China, both facing same issues most countries do of these data silos. It was very curious and coincidental that President Trump in March 2025 issued an executive order ostensibly targeting waste, fraud, and abuse. And wanting to break down the data silos in the federal government in the United States. But also, as was made clear through other executive orders and actions, they want to support AI development. And it feeds into a very long-term debate in the United States is how, given these concerns about privacy protection and concern about data pools being vulnerable to attacks and abuse and leakage, how can you better share data to enable informed policymaking, which again is one of the same motivations that we find in China as well. So there are very legitimate concerns here, but because it's the Trump administration and the way they've been carrying it out, created a lot of concerns. And just 2 months after this EO, which, as I said, got a lot of attention in certain circles in the US, China announced these data sharing regs. And they had not put them out for public comment. That had been on their legislative agenda. We knew they were coming, but because I assume this is an internal intergovernment thing and it's not, a public-facing system, they didn't feel the need to seek public comments. And I'm sure they got a lot of input from scholars along the way, but it was sort of a surprise once what actually came out. But similarly, they want to break down the interdepartmental silos, safeguard. I was really happy to see, big emphasis on safeguarding privacy, of course, state and commercial secrets, and of course, data security, and enable the digital governance project, the broader project, as well as AI too. So we have very similar motives and concerns in the two. And of course, this effort builds on decades of progress in China as well, dating at least to 1997. It probably goes back farther, the idea of trying to have information resource sharing, interconnection again. And you can see as you go on, the big data action plan in 2015 was the first national policy that talked about encouraging the government data sharing piece. Xi Jinping gave a talk calling to break down information barriers in 2016. And just a couple months later, the State Council came out with some interim measures on government information data sharing. And I remember there was a scholar from Guangzhou came to the United States to study how did the US do it. And I remember thinking, oh, I hadn't thought about that because I was so focused on, at that point, the Chinese government disclosing information to the public. So the open government information thing has my main focus, not the internal government sharing. But clearly, the State Council was already beginning to work on it. And I was quite struck that those measures in 2016 actually built on a lot of the infrastructure of the open government information regulations. And I'll talk more about that later. So it was interesting. There was sort of a learning process from some of the things that Shanghai had decided to do to try to make sure that their regulations, unlike Guangzhou's, were actually used and implemented. Some of those mechanisms were in the 2016 measures, and we see them again in the 2025 sharing regulations. Now, one of the, again, very annoying thing is there was a document that came out in 2021 that a lot of other documents refer to, but it's not publicly available. That was apparently the first one that really focused in on setting up, a mechanism for interdepartmental data sharing through some sort of coordination mechanism, which I assume has been, but who knows, overtaken by the current regulations as well. So we have a long history of trying to address this issue. And so one of my questions is what they've now done in the regulations really going to work? Is that going to solve the logjam, if you would, in terms of intergovernmental sharing? So what do the regulations cover? So this raises yet another issue. What they cover is 政务数据, government affairs data. Now, the 2015 big data thing talked about 政府数据, government data. So what is the difference? So government affairs data includes not only data generated by actual administrative organs, but also by other organizations authorized to perform public tasks as well, too. So I'm just going to call it government data most of the time here. And I'm working on a translation, and that was one of my issues. Do I use that's a mouthful, government affairs data. But I always think when China uses different terms, it should be important to reflect those in English translation so people understand there are nuances. The problem is if I don't understand what the nuances are, then it's quite a challenge. So that's run through this whole project is vocabulary and data terms, and I'll mention that a bit later too. And then it covers only data sharing, so it doesn't cover data openness, or other forms of data circulation or utilization. So sharing is just defined. Department A wants data that Department B has, and so A is how A gives it to B and what happens with that. And et cetera. So, and it's internal only, has nothing to do with disclosure. So again, I say it's not all these other things that China is also working on, or talk about much about data collection, et cetera. It's just one piece, but it's a very important piece. The way I view it is the data sharing piece is to increase the supply of government and public data that is going to be now available to be utilized for economic development, for public welfare purposes, and of course to feed into AI project as well. And then there was AI, put a footnote down here too. So we also have this other term that comes up with public data, 公共数据, which is also mentioned a couple times in the regulations as well. And the main difference between 政务数据 and 公共数据 is that the latter covers party organs that are performing public duties and are generating data. So immediately I thought of the Cyberspace Administration of China, the Wangxinban, which is really a party entity, but is given statutory responsibilities and authority in areas of privacy and data security, et cetera, cybersecurity. So if CAC is developing data through those operations, then that becomes part of the public data, which is then covered by other systems that are being set up. So one question is, why isn't that data covered by the sharing regulation? Sort of an interesting side note there. So how does this work? Actually, the first step is, the primary responsibility for data sharing is put down at the department, the government department level, whether it's central department or local government departments. And they are responsible for setting up a specialized office to handle data sharing things. And it's a lot of responsibilities. It includes compiling the data catalog of all the data that they have, and then classifying the data, and then handling the sharing procedure and everything that goes along with it, ensuring data security, data privacy, et cetera, et cetera. So these are going to be very important offices with a whole new burden, but no new bianzhi. This happened with the Open Government Information regulations too. And this was one of the innovations that was inspired by US practice, because we decided someone has to be given responsibility if this thing is going to work. And so under the OGI regs, you have to set up a special Open Government Information Office too, that'll handle that specifically and be responsible for it. So same thing under this model, you have these offices within the government departments being asked to do all these things. So once they compile the catalog, one of the major things in the catalog is how you're going to classify that data. And they use this three-part framework that had been developed in other contexts prior. So you've got data that can be unconditionally shared, and I'm assuming that includes the data that is open data as well. And I said, if it's open data, why do we need a special procedure like this one to request it and get it back? And it was pointed out, sometimes open data may not be in the format that you want to be able to use to make it interoperable, for example. So then you would go through the request procedure to receive data in the proper form. So the second form is conditional sharing. Okay. So this means you can only share it with specified departments or maybe with some people under specified conditions. Unfortunately, the regs don't give us a lot of insight. These are just speculations based on what people have been writing and commenting about it, is what kinds of data are going to fall into these different categories. And the conditional sharing category is the category which also includes the kind of data that's used in this other mechanism that's being set up, the authorized operation of public data, which is sort of a franchise data under which the government gets paid a fee for providing data that's then commercialized. So you have conditional sharing, and then you have non-shareable. So we assume that state secrets and work secrets, which under these regs, both state secrets and work secrets are defined as not being Zhangwu Shuju. They're not just an exception, they simply are not in the definition at all. And it would include core data, which according to the research I've done is not necessarily the same as state secrets, although I don't know what the difference is yet. So you've got these three categories. And so you're supposed to specify for each item of data you've got what kind of category is in there. So interestingly, also these regulations, unlike the 2016 measures, do not explicitly say there's a presumption of sharing. And that was of interest to me too. The original OGI regs did not explicitly say there's a presumption of disclosure, but they did, and when it was revised in 2019. And the way the regs were crafted, it made clear that was the intent. Well, that's what's going on with these government sharing regs. They don't specifically say the presumption is you should share your data, but it's got all kind of clauses in it, like a prohibition on arbitrarily imposing conditions on data that would make it not shareable. So there are other ones that say that, although you'll see we've got time limits set in here too, they encourage departments to act quickly and get the data out there as quickly as they can, et cetera, et cetera. So it's clear there is a preference that people be sharing their data, but I don't know why they didn't explicitly say that. So this is a very important part of what these data sharing offices and the government departments are supposed to do. So it's all based on a request procedure. And interestingly, under, again, OGI regs, they talk about filing an application, or in the US, we would call that a request, 申请. For this one, they use demand, 需求. So you're a 需求部门. So I don't know why they use a different term, but it makes it a much stronger kind of thing. I'm not just requesting, I'm demanding, I need this for my work. So your demand department looks through the catalog, figure out who has the data he needs, and then they request. But in the request, they can't just ask and get it. They have to specify the purpose, how long they're going to use it, what for, what method they want. We've got different methods to share, and then provide a legality guarantee, meaning my request is legal in accordance with law, my use is going to be lawful, etc. And this is important because apparently one of the obstacles to sharing in the past has been the data source department has a lot of liabilities for data security, privacy protection, et cetera. And they were worried if they're sharing data with other departments and the other department screws up, that they're going to be held liable. So, and a very important thing these regs do is clarify the liability. And as we'll see, the liability shifts to the data demand department. So they issue the demand, the data receiving or providing department is given 1 day to decide whether or not to share it, because they're supposed to if it's unconditional, for the unconditional data. If it's conditional sharing data, they're given 10 days to decide whether they're going to share it or not. And during this period of deciding whether to share or not, there's another of these stipulations that if you get a request that's unclear or insufficient, don't outright reject the request. Go back instead and tell them what you need to be clarified. And then the 10 days starts from that period too. So this is, again, to encourage sharing, because this is something they did under OGI. They just reject the request and move on. And so people would have to refile and go through the whole thing again. So then once they decide to request, if they're going to share it, then they get 20 days to actually put it in place. And again, then the regs say you have 20 days, to put it in the right format or whatever, but we encourage you to do it more quickly. And if you say, I can't share it, then you have to give a reason why. And again, that was in the OGI regs also. So you have to make clear why not, so that it can be challenged later on. So then once the data is then transferred, the data demand department gets all the responsibilities for data security, privacy, et cetera. And then an interesting addition is that when the use is over, they don't need it any longer, or the time limit they specified expires, they're supposed to dispose of the data. They can't just keep it. So, and that's why, well, what did they actually do with it? And apparently that's whatever the providing department told them they wanted done with the data is what they're supposed to do. Moreover, they've got a record keeping requirement imposed. They're supposed to keep a record of how they used the data while they had it and how they disposed of it, and keep those records for at least 3 years. So this is a pretty strict procedure. I showed these regs to a US government official who served as the sort of administrative ethics and FOIA appeals type officer in a large federal department. I sent the regs, who'd also done work with data. And I said, what do you think of these regs? And their response was, wow, it sounds to me like the Chinese government does not want departments to share. And I said, whoa, why did you think that? And they said, because this is so complicated and imposes such a burden on the departments involved with everything. So this is that's the question, is this complicated, procedure going to actually work, even though each step is very commendable. We understand why they're doing it, but the end result is this takes a lot of work. So what is the architecture for this? So they're building a national government affairs big data platform. So any data sharing at the national level now is supposed to go through this platform. All the state council departments and provincial governments are supposed to be integrated with that platform so the data can be shared upward. And then interestingly, the regulations don't specify that this entity that's responsible for data sharing in the state council is the National Data Administration, but a lot of the commentary makes it clear. They do what a lot of Chinese regulations do and just say the Youguan Bumen, the department in charge under state council will do it. And the same thing at the local level. The local data sharing departments will do it. Well, who are those? So it's interesting. The NDA is a new entity, but they don't have a national structure. Unlike CAC as a national office, right? And then you've got provincial CACs, although most of them are located in the party committee at the local level. But at least there's a structure, a CAC structure. NDA, they don't, because they had a lot of predecessors already existed, big data entities or other forms of data related agencies and different structures. And they apparently all still exist. At least according to AI. That's one of the issues I want to confirm too, is what is happening to the structure here too, because that makes it a little more awkward. NDA can't, directly tell them what to do, et cetera. So you've got this, national structure that's set up. Interestingly, it only goes down to the county level, and the county level governments are supposed to be responsible for sharing with and obtaining data from, the township level. And the village and local community level as well too. And then all the sharing takes place through this national data sharing and exchange platform. So I spent some time trying to figure all this out. With OGI, I didn't try to figure out the technical side. How does this actually work in process? But because I'm so interested in the data pooling issue, I wanted to find out what is the technical architecture as well. And I sort of have a general idea, but I'm still not totally sure. So this, again, was AI set this thing up. These are just some of the main aspects. In addition to setting up this general structure, there are a lot of other things in the regulations. One is because if you're now going to be sharing data, government departments should be able to obtain all the data they need from other departments rather than repeatedly collecting it from the same person. They've got this phrase they like to use, They want this system to make the data run around and do the work, not people having to go to all the different windows and departments and keep giving them the same information over and over again, to get something done. Now you're supposed to rely, if you can get it through sharing, don't repeatedly collect. And this reminds me, in the US, we have something called the Paperwork Reduction Act, which I'd never paid much attention to, but its original purpose, too, was to avoid burdening the public with constantly asking them to give you data over and over again. Quality management. Another really interesting thing was they talked about the shuju huiliu. So this data return, it's an upper level departments should return the data to local departments. The thing, well, the local departments collected it, so they probably still have it. They just share it up. And apparently that's not the case, particularly in some of these, they're called the vertically integrated departments, like tax and finance, et cetera. And again, I'd noticed those within the context of open government information and realized that in those systems too, the information is not shared with local governments. It goes directly up to the central department. And apparently a lot of that data is just collected through the government system. So it's almost automated, so the local government never sees it and they don't have it. And so the idea is they need that data to perform their duties. So now it's explicit. First time they've made this data return obligation very explicit as well. So it'll be interesting to see how that works. And they also implemented a very interesting verification and correction process. So if I demand data from you and I get it and I find out, oh, that's the wrong person, or this is outdated, or something's wrong here, I'm supposed to go back to the data providing department and tell them, and the data providing department's given 10 days to correct it and give the data back. So it's a way of helping ensure data quality. But again, it's yet another procedure that's going to create a lot of work for overburdened departments in the first place. And then, there's a big focus. I mean, everything that happens in these regs is subject to overarching cybersecurity, data security, personal information privacy, protection obligations too, even though particularly the security side isn't emphasized in these regs. But on the personal information, it is. And one of the things the regs warn against is what we call the mosaic effect. I don't know how they're going to do it, but they tell departments to guard against the effect of if you're aggregating data together, even though it's been de-anonymized or put together in statistical form, be careful that with all the data coming together, you're not suddenly revealing stuff about companies or individuals that we're supposed to keep private. So again, I don't know how they're going to do that, but that they raise this as a problem related to data aggregation, I thought was very interesting and significant because we have same issues, of course, in the United States. So again, how does this fit into the broader data ecosystem? As we said, it just covers the data sharing portion. It's not covering the data opening, even though the two are often discussed in policy documents in one phrase, data sharing and opening. And very interestingly, the data opening project has been going on for a long time. And at the provincial level and local levels, you've got open data platforms. You can go get a lot of data from them. And you've got some like the State Statistical Bureau for years has been making a lot of very useful statistical information open. So, I mean, there is data open at the national level too, but there's no national open data platform yet, even though they've been calling for that for a long time. So it's a very interesting question of why not, what's going on with that, and are they planning, because I haven't seen any mention of coming out with an open data regulation or law that some people are calling for, because that's obviously an important piece of this too. And then, as I mentioned, this authorized operation piece with public data. Some of the government affairs data is public data is somehow supposed to be used to sell to entities, which would likely be SOEs who will put it together, package it, develop products, and commercialize it. So if it's for commercial purposes, then they're going to see this is another way to help increase the data flow and utilization, doing things that maybe are more difficult for government departments to have personnel and expertise to do. So a lot of people are writing about that. I still don't understand how that's supposed to work too, but this will help make more data available then, some of which is going to be funneled out through this authorized operation procedure. So how am I doing on time? Because I want to leave time for discussion and questions too, but very quickly, again, actually who implements the regulations are the departments. Who oversees it are apparently, you know, the National Data Administration and then all these other administrations as well, as we discussed. So what is the import of this? You know, it's the first binding legal framework to require data sharing. I think it's an important, at least statement, aspirational of what they want to do. It bolsters the earlier measures. It makes clear the liability issue, which has been a big concern and obstacle. Mandates the data quality, this error correction mechanism, very interesting because you worry about, particularly when you're pooling data and sharing it, what do you do about updating it? You're supposed to, the regulations call for dynamic updates, you know, but how is that actually going to happen? Particularly if the data is not just here, but it's also already been shared to someone else and you've got to update it for them too. So it gets very complicated. And then the questions that remains to be done. So in the course of this, you know, a lot of the challenges and what I've been going through is not only trying to understand, oh, and I didn't see it there, but I was going to, how data is actually shared. The regulations designate three ways. I think it was in one of those that I probably didn't do. One was like a file exchange, a data download, and another one that's really API. And it turns out, I mean, the general idea here is not to aggregate data in most cases, but to make it through what the systems that protect privacy. So it's more like the data remains with the original agency, but it's able to be interrogated and queried, you know, so it can, data is available, but not visible. You know, data remains in the domain. And this is an underlying approach. It was articulated in an important document called the 20 Data Articles, you know, issued in December 2022 by the party and the State Council, which also called for data sharing. And it runs through these regs if you look at what the actual methods are. Although the areas that are aggregated, it's interesting, there are data pools for like the basic data databases, you know, the public, the population data, including HUCO registration type stuff. One of the other ones would be geological and geospatial, natural resources data, enterprise registration data, social credit data. That's a big one. So that is pooled and aggregated up at the top too. So that is including one. But when you're trying to access it, you know, it still is through a query thing. And with the social credit stuff, the stuff that's publicly available is the kind of, it's like open data, it's open information. So it's already been information that's not private or commercial secrets. So that's an issue too, is how it's done. And I was quite reassured that China also has a strong recognition of the dangers of data pooling, even though in some cases, you know, they do have it in place. Because you certainly, a country like, we've already had a lot of data breaches in China, so they know well enough, as we do, how vulnerable it is once you've got big pools of data. So the terminology, as I mentioned, is an issue that I keep. Why do they use certain terms in certain contexts and not others? And there are a lot of different definitions floating out there. I mean, this doesn't even mention the problem of at the lower level. You know, a lot of they've been first movers to come out with regs using these terms and giving them yet different definitions too. So, you know, what was the different between information and data? Information was defined to include data. What are information resources? That is developed over time. And certainly in the data context, it seems to mean data sets. But sometimes the regs talk about data sets. And so why use that instead of data resources? So I'm still struggling with a lot of this. And then the government data versus government affairs data versus public data, why is it used in different contexts? And I've tried to see if there's a logic to it, and sometimes I just can't figure out why. And the data resources. And then when I'm so worried about this pooling issue too, they use so many different terms that in English are often just translated as integration, which suggests that maybe it's being pooled. And again, after going through it a lot, I realized that it's not. In fact, the integrated mostly it's not Tunghua. That's centralized. It's I forget something anyway, but it's a different term that they use. Jet lag. And then the challenge of this unpublished document that seemed to have been an important step, and then we've never seen what it was and why it was too. So, I mean, I see these regs as really foundational, and it sets up a very important piece and an important source for data supply. All of the discussion of getting, AI ready data sets rely heavily on the public data portion. I see that same in the old days when they were doing the open government information regs. They said 80% of all the information is held in government files. Well, I recently saw 80% of all data is held in government files. So the point is a lot of data is held by government. So it's a great step in trying to now make it at least more accessible to other government agencies who then can make it more accessible to the public, hopefully. And they address a lot of institutional challenges, but set up a whole new bureaucracy. So is more bureaucracy the answer to this or not? A lot of you may know Zhang Bixin, formerly on the Supreme People's Court, and I would think of him as sort of a judge scholar type, who's been involved in a lot of administrative law projects over the years. And he was commenting, he didn't know how this was going to work because he said the main problem is you need to give incentives to government agencies to do the work, i.e., you need to let them make some money because they don't have enough money, they don't have enough people. So I assume he likes, and that's part of the idea behind this, authorization, Shouchuan Yuanying model that they're going to try the franchise. But we'll see, because I think this is a very impressive structure that they've set up here. And I think it's a good model for the US to look at. But again, the question is it going to accomplish what it wanted to do? And looking ahead, now they've got this in place. So that's one task finished. Now they've got it there. And so for this year, NDA's, National Data Administration's priorities are focusing on high quality data sets being produced for AI as well as public welfare purposes, et cetera. And then, of course, they're working on a data factor market as well. And the ultimate goal is to be aggregating public data together with voluntarily provided enterprise data, but to get all of this so that more data is flowing and being aggregated and used successfully. And the overall impression is that really the focus is not so much on the data security piece, although it's there and it's important too. It's really on utilizing data and getting it to really, unleash its benefits. So I'll stop there, and I hope some of you can help me answer some of these questions about how this is working and might work in the future. Thank you.
Thank you, Jamie, for this talk. I think it's very rich and interesting. So unfortunately, I can't answer any of the questions, but I do have one question for you, if you don't mind. So I ask my question first, and then I open it up to the audience. So in the area of information opening and sharing in the judiciary, we know that the database on the Chinese judgments online have been developed over the past 10, 15 years, and has gone through a fundamental transformation in recent years. Right, before it was primarily to open information to the public, right, for scholars and the public, they can have easy access to the judgments through the database. But since 2020 or 2021, right, it has been closed mostly to the public, and instead it has been transformed into a data sharing effort among the courts of different levels in China. But at the same time, the public facing, the opening function has mainly stopped. So I wonder, since you've researched both government information sharing and opening, I wonder what's your perception on the dynamic between the opening initiative and the sharing initiative that you talked about today? Do you see them as mutually reinforcing, or are they more or less substituting each other?
That's a good question, and I haven't followed what had happened. My impression was that they've reopened the public-facing database. It's just that it's not as complete as it used to be. And of course, one of the reasons given to us was, that a lot of data was, or case, related data was put out there that had not been properly redacted for private information or sensitive information. But of course, there were a lot of, and I remember reading Professor Hohaibo's critiques, et cetera, is very brave. So I don't really know where it stands now, but it is concerning because the two should go together. I mean, you have more sharing, like in the social credit field, they've got a lot of the information goes up to an internal database, which is more complete. But then a lot of that is intended to be made public so that it can be used, to be able to evaluate your business partners, et cetera, et cetera. And that, I think, should be the model. And that's why even in the policy documents, they link data sharing and data openness together. So I'm not sure why, other than current political situation and the current head of the court, that the publicly available cases are so much more restricted now. But I know some of the people here are working in the court, and maybe you have a comment on that. Do you want to comment at all? Yeah.
Thank you. I am doing internship in SPC now, and I actually don't. I know the situation that the public cannot get the full information in the judicial court. I don't know the leader's opinion on that, and I don't got any information because I just interned for 1 month. But I will keep observing this. Maybe I will talk to the judges later, and I can share with you. And also, I want to ask a question that I think it for many years. It's about the social credit system, and I know that you are not like a totally Western view that the about the authoritarian view of Chinese government collecting all the personal information and to surveillance as a surveillance machine. And so my issue is still about the fact whether so how deep the Chinese government gets the personal information because we as a individual we conduct but not realizing that what this kind of conduct will be interpreted into data and interpreted into information gathered by the government and this kind of collection is controlled by the government and as you said it is we need a lot of burden to ask the government to provide it or not. And they may feel burdensome as well to provide it or not. And I don't know, maybe the question is whether the individual should have the authority or ownership of the data from themselves, or we should trust the government. So I think I don't know. It makes me sometimes feel scary. Yeah.
Well, first of all, and I didn't mention that too, but that's another important piece that's coming is the question of data ownership, because that is still being developed in China. And it's a piece that I want to look at more carefully. And there's a lot of different vocabulary around it as well, too. Though with the social credit system, I think there's a lot of misunderstanding about that. And it was confused with the kinds of so-called social credit systems being run by, the platform companies as well, too. So again, the social credit system only collects regulatory information about administrative actions. So like fines, et cetera. It was mostly set up and mostly used for companies in the first years. And the main individuals that would show up in the social credit system were professionals who have a duty, a responsibility, to society, lawyers, bankers, corporate executives, accountants, et cetera, not ordinary people. And so the social credit system doesn't collect information about people's conduct per se, unless they've done something that leads to an administrative penalty or a court decision, because it also includes information about, if you've been in court, and what the judgments are and what they were about. But so the social credit system was totally misunderstood at the beginning, including that it comes out with a score. But the broader situation of, personal information and surveillance state and all that, because it's clear that the law enforcement, public security, state security, are monitoring and surveilling and collecting real-time data about people too. But that's, again, being used mostly for their own purposes, not, at least I haven't seen it related to being shared, with other agencies, although it could be. I mean, that's actually a very good question. I don't know what's going to happen to the kind of security type information, but I assume it will remain siloed because it's for a special purpose there too. And I must say that these regulations, again, it's interdepartmental, so there's no discussion of the right to sue or whatever. One thing that I think made the open government information system work is that the public could sue and go to court if they weren't getting the information they wanted or on time. And it sort of had an outside, and they had to get annual reports about how much they were disclosing and, what was going on. This interdepartmental, they don't have those external accountability mechanisms, of course. And they only, if there's a dispute between departments, they're supposed to consult and mediate and just work it out, right? If third parties feel that their rights have been infringed under the regs, they're given a right to file a complaint, which is not too satisfactory. But again, under privacy law and other laws, they probably have other remedies that they can also pursue on that. So
yeah,
anyway,
thank
it's
you.
very complicated. Yeah.
Also, I want to add a small question. I actually do some research on that topic of whether the social credit system includes the personal information or not. I think maybe the agency allocate the responsibility to the platform, to those big tech companies, and they may gather the personal information for their own business model, and they may, because I know that they have the report responsibility to the government. Yeah.
But there, I think you have to distinguish between credit reporting piece, because that's also part of the social credit.
Yes.
And interestingly, the People's Bank of China, which runs the credit reporting system, has never shared its data with the social credit database. And I think it's because it's highly sensitive information, just like in the US, it's protected. So even though they, together with the National Development, Fagaiwei, are responsible for running it, they've always been outside of that. And so there are projects to work with platform companies and others, in the credit reporting area.
Yes.
But that's only a special little piece of social credit. That's not, it's a very, and people get them mixed up all the time. So
yes.
Yeah, I think you have to distinguish between the two there. Yeah.
Thank you.
So I have two more you, and then I'll ask you. Yeah. You, yeah.
Okay, I am a student graduated by Peking University, as I say. I have some questions to answer you about the Hong Kong data trading. She's my friend, and she's working in an insurance company in Hong Kong. So, as a professor in China mainland, he told me that if we get some information about insurance in Hong Kong data to the university, and the team will use it for something for business or for data protecting. So do you have some suggestion of this way?
I'm not sure I understand the question. So again, who's getting data from who?
A university team want to get the insurance data, and
what kind of data? 中文也可以用中文。
Okay, a professor from Huadong Normal School, and she wanted to do some research about the insurance model. So need some data about the insurance, which he can get the data from AIA insurance company. Yeah. I wonder if this is a regulation because the insurance company in Hong Kong, but the professor do her research in the mainland.
Well, but they're a private company. So normally the private companies, as said, enterprise data so far, there's no obligation unless as a insurance is a heavily regulated industry. So there's some data that they probably have to provide to the government, for them to supervise, how they're operating. So, but apart from that, companies aren't obligated to share their business data with the government. There's certain things they have to share because they pay taxes and regulation. But otherwise, if a professor wants to get data from them, they should go talk to the company because sometimes they can work something out and they're willing to share it if it's kept confidential, for analytical purposes too. And this is something China's working on down the line because they want a lot of this valuable corporate information to be also made more available. And that's why they're trying to work out these data markets, where it'd be a voluntary provision of enterprise data too. So it's a complicated issue because insurance is regulated. So I know they have to provide some information, but I'm not sure what kind she's looking for. And then you've got the cross-border data issue as well to work out. So yeah. Okay.
Thanks for your presentation. I'm visiting HKU and otherwise work at the University of Warwick. My question, I have two questions. One is around how the data exchange regulation is framed, and in India, for instance, we have a lot of discussion around digital public infrastructures. And digital public infrastructures are seen now to constitute data exchange systems, digital ID, and digital payments. And I was wondering how you see the framing of this regulation in terms of a larger national data infrastructure that's meant to sort of speak to a public purpose or a public interest. And do you also see this as sort of joining up several other initiatives, and in how far can this be seen as one piece, or are there other pieces that you think this will eventually join up with? And my second question is, you categorized data sharing into conditional, unconditional, and restricted.
And not.
And I was wondering, how does it work where it is difficult to be able to neatly categorize these things? So what happens in cases of aggregation, or where you can use exceptions for national security? In that regard, are there kind of precedents that lie for certain situations, and where does discretion hold for government officials, etc.?
Yeah. Well, so on the first one, yes, I think they see this regulation as helping set an important foundation because so much of the other pieces of the digital architecture depend on access to the public data piece. But I see it more as providing the supply, right? That it's there and it's more available because more government departments have access to it too, and through different channels. But yeah, it's part of this architecture they're building that'll have the data markets, all kinds of data exchanges, which so far haven't worked too well with private sector data. But yeah, the whole idea of operationalizing the data generally. And they've got you find a lot of the information about this in the standards that they've been coming out with too, I discovered. If you go in and look at that, and they've got charts about how this is all supposed to work and how the data flows and all that kind of thing too. So there's more information out there that I'm just beginning to focus on as well on that. And so I'm still exploring it. And then what was the second question again?
How the different categories work.
Oh, yes. No, I agree with you. I think it's probably sometimes not all that clear. And that's why there wasn't that much guidance in the regulations themselves about how people are supposed to categorize it. And that's why I was trying to think and get it. And that's why, again, I told people this was AI, did the PowerPoint based on my draft reg, but I had been interacting with AI a lot, asking questions, and they were pulling in stuff that I hadn't put in my paper, trying to figure out how all this works on that. so I mean, that's one of the liabilities, I think, that here these departments have to make a determination, and what if they screw it up? So, and even with the non-sharing, one of the commentaries I read said that in practice, if you really want data that is deemed sensitive or state secret or whatever, the departments can talk to each other. And if they make the right case and the right promises about security and everything else, then sometimes they can get access to it. So it's not totally walled off either. So between the three of them, there's, a lot more fuzziness too. So yeah, I mean, I agree with you. I think it's a difficult, sometimes it's clear cut, sometimes it's not. And that's one of the liabilities departments have to live with. So okay, back there, Marianne.
Thank you for the fascinating talk. So I have a question about the use of data sharing in judicial enforcement. I wonder whether that's part of the same regulatory regime or is it different? Because it seems that a lot of courts use that they share the decisions with other departments of the government, and then the other departments or the railroad companies help them enforce the decisions made by the courts. So it seems like a different kind of sharing, because this time is the courts like actively sharing it with other departments so that they can help using it, rather than the other departments like demand the data from the courts. Is that completely different from this, what you've been talking about? Thank you.
Yeah, well, I mean, it's related because it's sharing for a purpose, but yeah, it predates it. And I mean, it makes you think of the social credit system, because the courts were the first to come up with this idea of the kind of the blacklist and working out memoranda understandings between the court and, say, the banking system and others to try and enforce court orders to pay money, for example. And the departments didn't have any obligation apart because there's no regulation that required it. So they worked out this MOU mode where, and then with the social credit developing, they did a broader kind of, they've got these joint MOUs with departments that are supposed to take into account, help enforce the court judgment defaulter issues too. So that is in somewhat a distinct, but obviously it's related because it has to do with sharing information, but it's not, this one is only about government organs sharing between them. It's not the government departments and the courts and the NPC and other entities as well too. It's only this one particular piece. And it's interesting talking of MOUs in the US government, that's a lot of how it's done. Federal agencies, particularly the statistical agencies that handle this sensitive information, but like tax people, they share their information with a lot of other government agencies that need to know things, but they often do it through, there are legal requirements too, but they do MOUs, so because it's a regularized kind of sharing as well. And I'd be interested whether China might adopt a kind of similar thing, because they did in the social credit issue. That was exactly the model they used. So MOU to try and have the agreement. And of course, the MOUs were all approved, and authorized through the National Development Reform Commission, and higher levels of government too, but not a law per se. Yeah. Marianne, yeah.
Thank you. Thank you for this brilliant talk, Jamie. I wonder, and this is maybe a tricky question, but in terms of like, how can we, or where would you suggest we look to understand how this is being implemented now that it's becoming more and more difficult to conduct fieldwork and actually talk to officials and see what they actually do on the ground in the local government agencies? Where can we look to better understand how this is implemented and what the obstacles are? Yeah.
It's a great question. I was thinking about that this morning because, again, with open government information stuff, they have annual reports. And I still look at it. In fact, this first year I was going to ask the intern to show me how we can devise a program that AI will just compile the statistics, because nobody does that. But every year I ask an RA to compile all the statistics that are reported, and how many lawsuits and requests, and to see trends. So that's one way that we know, and others through court cases, because people can sue if they're not getting it. With this, it's a totally internal system. So, and it's not transparent to the public. So I don't know. It's a good question. Other than reading you know, you just have to start poking around. There are a lot of interesting articles written by people about systems, you know, and how things were working up to 2018 that would apply to what's happening now too, that give you insights into what's happening. But, you know, some of these state council information office briefings that they hold when a new reg, you know, sometimes there's a lot of good, but it'd be a matter of digging because it's not going to be publicly available. Yeah.
Are there specific departments like the tax administration, whatever, like sectors, so to say, where it's easier than in others? Would you say? Did you like find a specific, yeah, which ministries or departments under which ministries are rather open, and which ones are rather hard to get at, in your impression?
No, but I haven't really started digging into that yet because I was still trying to understand how the regulations were. But these are questions I've been wondering how it's because now it went into effect last August. So, you know, it'd be interesting to find out and to see whether the National Data Administration may issue a report on it, you know, because they must have at least internal reports they're going to be doing on how it's going, because this is supposed to be part of their KPIs now. But that'll be a challenge going forward to see where we're going to be able to see if it's working. Yeah.
I will do it very fast. Thank you so much for wondering, sharing. And I have a small question. Like you mentioned, the data openness and the authorized operation of data, and you say maybe the authorized operation of data would be helpful to make the data more available. But I'm really kind of not sure about this because you know things are the real things happening in China is that the government can make some mm, economy benefits through the authorization
Right.
operations. And then I would say maybe this could cause some crowd out effects to the data openness because while I would say these economy effects may incentive the governments to choose the paid use of the public data approaches. I'm not sure
Yeah.
whether you.
No, I totally agree with that. I have a lot of concerns, and I was happy to see other scholars are writing with concerns like Wang Xixin and Peng Chun, people I know, and I found out they've written about it too. So I think it's a very dangerous system, and it could create a lot of corruption and monopoly. You know, you're giving a franchise for certain data that's going to then be sold on. And you're right that one of the concerns is that the way it's set up is that the same data being used for public uses, public services, public welfare is supposed to be freely available. But then if the government departments know they can make money by giving that data instead, you know, for commercial development, I mean, the justification for this is that it's another channel through which to make data more available to private and commercial, you know, for economic development purposes. But I think there are real concerns about, as you say, all the negative incentives that it could introduce. It's a sort of dangerous thing. And I was trying to figure out where this idea came from. And it seems to be in the EU, they had a similar idea in some of their data legislation, particularly early on, that said, you know, same thing in the US, you know, you have a lot of cash strapped departments and some need to earn a little money because they otherwise don't have the equipment and the people to, you know, do the data sets and form, you know, make it interoperable, et cetera, et cetera. So maybe they could charge a small fee. But then reporting came out, you know, 10 years later or whatever, saying, no, even a small fee is a market, an entry barrier, you know, a barrier to access for the data because people, even a small fee, they can't pay for it. So and clearly saying the preference is make public data is public data. It should be freely available to the public, you know, but I really would be interested to see whose idea this was and where it came from and who's been pushing it because it is everywhere. And like I said, I've seen a lot of scholars are writing about this, but it's usually at a very theoretical level. You know, I don't know how it is working so far or expected to work in practice. And I think it has a lot of risks attended. But I mean, you know, it's innovative. So yeah, maybe they can make it work. You know, let's see how it goes. Yeah.
Okay, so due to the time limit, we'll have to end the formal part of the talk. Thank you all for the questions, and please join me in a round of applause for Jamie.